G'day there guys, how's it going? Markee here, back again with another episode of r/legal advice. Now with that said, I want you to sit back, relax, and enjoy the bloody good content, and don't get arrested in the process. Posted by user Ramirito Barrera, titled, "My dog was attacked by our neighbor's dog, and now they are accusing our blind dog of biting the other owner." Katy, Texas. My family mini schnauzer, who was disabled and blind, was walking along our backyard fence, and suddenly our direct backyard neighbor's pit bull broke our fence and grabbed our dog by the neck and dragged him through the fence onto my neighbor's backyard. The pit bull proceeded to attack my dog, biting him in the throat, neck, and chest area. In hopes to save our dog, my sister managed to go to the neighbor's backyard to free him from the pit bull's mouth. While my sister attempted to free our dog, the woman at the property was unsuccessful at holding the pit bull back. After several attacks, my sister was able to hand our severely wounded dog to my mum, and she rushed him to the animal hospital. We called the police and animal control to come out, hoping they would take that aggressive and dangerous dog, but they didn't, because it did not bite my sister. The police did not do a police report because it was a civil case. Ultimately, we think the pit bull's owner should pay for our dog's vet bills, about $1,000. My family went to speak with the family in a friendly manner and asked them to pay the bills for our dog, and they refused to pay and kicked us out of their property. We found out that the pit bull's owners are just renting that house, so we got in contact with the actual owner of the home. He told us that the people living there broke their contract by having a dog on the property, and since that last conversation, the owner has been trying to talk to the renters, however, they're not even answering the phone. My father wants to take legal action. He went to the courthouse today to make the claim, but things just got a little more complicated. The pit bull's owners called animal control this morning, 3 days after our attack, saying that our schnauzer bit the woman, which is false. My sister was there when it happened, and if she really got bit, it was her own pit bull who probably bit her. During the attack, our dog was almost dead, and remind you, he is blind also. In conclusion, we don't know what to expect when we go to court, or what to do, or what the right steps to take are. Please help. My question here, for you guys that know Texas law, as I saw another story before about a dog breaking onto a property and attacking other people's sheep, if they had just gotten out a rifle in that situation and shot the pit bull, would they actually be in trouble? Or would the neighbors be forced to reimburse the people whose dog got attacked because of the way that laws work in Texas? I'm not sure. This is a really interesting case. Take pictures of the broken fence to show that the pit bull broke onto your property, unless they seriously want to try to claim a mini schnauzer did it. I would file a small claims action for both the vet bills and the fence. You can also contact your homeowner's insurance due to the fence damage. However, be aware that there is a good chance that they probably don't have the means to pay a judgment. Settling for watching them get evicted for having the dog without permission might be the best route. I agree. I highly doubt that these people are going to be unable to pay anything, since they will probably have to pay their landlord quite a bit of money for breaking the lease via not following the rules. Seeing them evicted might be your best bet. The house is no doubt insured by the landlord, so it may be worth filing a claim with them. Please correct me if I'm wrong. We have pictures of the fence, and well, the landlord himself is not being very helpful either, so we don't even know how we can contact their home insurance. Unfortunately, there's no registry or database with that information available, so to find out, you'd need to ask the homeowner. If they refuse, then you'd have to serve them with a lawsuit, and they'll have to get their insurance involved then, or be forced to pay themselves. The dog owners may have renter's insurance, which may cover them, but they'd have to provide you that information. I'm not confident that it would even cover a dog bite, but it's worth pursuing. Yeah, my dad served them with the lawsuit he put in today. Yeah, the problem now is they are claiming our blind dog bit one of our neighbors. Well, they're going to have to prove that your dog bit them, which seems unlikely. They'd have to bring a suit against you if they want money for medical bills. They either want that or it's retaliation, and they're trying to get your dog taken away. But I seriously wouldn't worry about that happening, especially if your dog has never had any other incidents biting or attacking people. There needs to be an established history of your dog being unsafe for them to take them away. Your neighbors sound like they suck. They're trying to scare you, You're suing me? Oh yeah, well I'm suing you. It's BS. If there is nothing in the AC report about the woman's bite, I doubt the judge is going to believe them. If your dog did bite the owner, it probably won't fall back on you since your dog was in an unusual duress while being eaten by their dog. If it was by her dog, any mark she would have would be obviously not from a miniature dog, considering pit bulls are quite large in the jaw area. Take them to court! I have a mini schnauzer that was attacked probably 9 years ago now. The first time my neighbour's boxer attacked him, no blood was drawn, so we let it go. The second time was horrendous. He was bleeding everywhere and had to get a tube put in his butt for draining. He is now severely screwed up from it mentally. He's 11 years old, and the past 9 years since the attack, we have to put him under for any grooming or vet visits because he gets so scared that he gets very aggressive and bites. My mum took them to court with all the vet documentation of what happened to my poor little doggy, and the dogs were removed from the property. We didn't have any pictures from it when it actually happened, just from when he was at the vet. Update: Neighbours dog attack. Katy, Texas. This is an update to an earlier post from this week. A few days ago, we put in the court papers to sue our neighbour for our dog's vet bills. About $1,000. The neighbours were served and they got scared and called animal control, claiming that a disabled mini schnauzer bit one of the residents' hands and arm. According to them, she went to the hospital a day after the attack. She did not even mention any bites the day it happened, and she had the opportunity to tell the officer or the animal control person that day. We are convinced that she was never bitten by our dog. If she had any type of bite, it was definitely from her attempting to hold her dog back. Nevertheless, these people seem to want to settle and not go to court. Duh. We were advised 2 different things by 2 different attorneys. 1. Don't do anything and continue with the claim. 2. It's okay to settle, but only if we type up a settlement agreement indicating the amount they need to pay us and saying that they cannot countersue us, and to notarize the document. So my question is, would a private settlement such as this be sufficient enough for them to not countersue us in the future? Is there specific language that we should add to the private settlement if we do decide to go this route? And thank you for all your responses in our other post. No one replied to them. It's really sad. I think that's where we leave this one. I'm sorry, there's no further. It's an update. An update's an update in the end. Posted by user trying to buy first time. Titled, Being Threatened with Lawsuit for $15,000 after attempting to release contract for contingents not being met. Or we can just buy the house. 4 days to decide. Obligatory throwaway account as mine is heavily tied to my location. Trying to summarize as best as possible, but there was a lot of back and forth between agents and cities. Questions. Attempted to release a house contract after seller didn't meet contingencies. Pool permits, complete garage reframing work and roof. Let us inspect after completion prior to close. Now telling us we have 4 days to reconsider or we're being sued for $15,000. Do we need to 1. Retain a lawyer now prior to receiving the formal letter from their lawyer? 2. Are we obligated to finish the sale though they didn't complete the work as requested? 3. If this requires a lawsuit, should we be represented separately from our agent? Background. My domestic partner, male, and I, female, attempted to buy our first home together in Ohio, in an area where most homes were built in the 1920s to 1950s. We wanted something renovated, with little work for us as we moved in. We have an agent to help us through this process, and a local mortgage broker, etc. Financing was set top tier. Contract. Found a home that was bought up by a flipping LLC that we loved and put in a full price offer on it. It was accepted at the beginning of March for a closing of the 4th of the 1st, or 1st of the 4th since this is Ohio and your dates are around the wrong way for some reason. Oddly enough, it was never updated to under contract, with or without showings, until last week, and people were still visiting the home until COVID. There was an inspection contingency on the initial contract. There were some things we expected to fix ourselves: tile work, back step/porch area, flashing on the roof, update doors, etc., even before the inspection. Inspection results. The day of inspection, it was pouring, and we found that the detached 2-car garage needed to be at least partially reframed, re-sheeted and re-roofed, as it was raining inside the garage and there was evidence of rotting wood and mold throughout the framing in the back. We also discovered the newer roof had 3 layers of sheeting on it, and it wouldn't pass code, let alone the weight with snow would probably impact the roof. The electrical box also needed an update as well as small plumbing fixes, updated commodes, water heater, etc., but didn't put a shut-off valve on, plus other smaller things. Negotiation. We asked via our agent that the contract to be amended, buyer pull permits with the city, fix these things, included full inspection reports, and outlined the major things we wanted done separately, and it requires a new inspection to pass, and then we would close. Because we loved the house, and the owner was an experienced builder, that's in quotations by the way, they asked for a sit-down meeting to discuss our list because they wanted to know what is wanted, some of the work could be done after closing. We declined and said, here's the list, it's pretty explicit. By the way, do we need to extend closing by a week or 2 for the work to get done? They said no, it would all be done by the 31st of the 3rd. And the contract was amended with new contingencies, but no new closing date. Permits. We currently live close to this house, and I walk or drive past it frequently for work and coffee. No work was done for 2 weeks. No permits, according to the local government, were pulled for any of the work as of the 20th of the 3rd. On the 24th of the 3rd, they began working on the roof of the garage, stripped of shingles. However, no permits had been pulled according to the city clerks, so we became worried. The next day, the garage had new shingles. Our agent contacted their agent saying, reminder, pull the permits. And the seller's agent said, they were using a contractor for this. They say the city inspector is aware of the work already and permits don't need to be done prior to work. Also, we do really want to sit down and discuss all this work because the list is long. We declined the face-to-face meeting again, and I reread the city code and website. Permits first. Work done on the 24th to the 25th of the 3rd. They began working on the main roof of the house. Our agent called the city again, and the city clerk told us, our agent, that they actually stopped them from roofing because there were no permits, and they don't know if ice guard was added. Permits for roofing were not filed with the city until the 27th of the 3rd, and even then, they were not done correctly. No other permits were pulled, electrical or plumbing, at that time. This is according to the clerk and our agent. Release. My partner and I considered it at length over the weekend. We aren't sure what was being done or if it were done correctly because 1, they didn't pull permits first, and 2, they just reshingled the roof without reframing the garage, and 3, we won't even be able to get it inspected until after closing date. Overall, we are really uncomfortable with buying the house now, and our agent said, yes, you can walk away. I'll write up a release. Email. Yesterday evening, we received a call from our agent and a letter from the seller stating that our reasons for releasing were false. The permits were indeed pulled at least after the fact. The inspector, not clerk, was aware of the work and inspected, and all the work was requested was done. It states that our agent should have done better investigative work. They accuse us forcing him to customize the house and never having the intention to buy, and due to the work and lost showing time, we've cost him at least $15,000. We have until Monday to reconsider closing on the deal, otherwise his lawyer is sending us a letter of intent for suit. My agent thinks he's just flexing his muscles, and she's going to talk to the inspector personally to see if the inspector tells a different story than the clerk. Question restated. Do we need to 1. Retain a lawyer now and prior to receiving the formal letter from their lawyer? 2. Are we obligated to finish the sale though they didn't complete the work as requested? 3. If this requires a lawsuit, should we be represented separately from our agent? Plus any other advice. Like, should we just get an inspection done again to cover ourselves? It sounds like the city isn't doing their job. Update. Attorney is reviewing the case now. Second inspection was completed. They made most, but not all repairs, and created some new problems actually. While we're not comfortable closing on the home, we'll see what our options are. Thank you all for the advice. You should read through the contract amendment. If they haven't complied with the closing conditions, then you don't have to close. If you do decide to proceed, you should first hire somebody to go out and look at the work they did. House flippers often take the cheap way out of problems, and you don't want to rely on them to take care of problems after closing. It's true that all of this might have cost him $15,000, but he also now has a new roof. So in answer to your questions, 1. You can have a lawyer review the contract and the facts and tell you what your rights are. Out here on the internet, we can only give general suggestions and don't have either the sales contract nor all the facts. That's a pretty good idea. 2. If they haven't met a closing condition, then you do not. 3. Too early to think about. If you have different interests, e.g. if one of you could interpose a defense that the other one did something wrong, then you would each need your own attorneys. Thank you. Reread the amendment that was signed by all parties. A lot on the list has not completed. Complete scrape and repaint of garage, for example. We did just schedule a second inspection for Monday. Now that we've been officially notified, the work was completed, so we can re-inspect the work. I'm going to start looking for real estate lawyers. Also, the city has verbally acknowledged, and we are awaiting on written confirmation that the work was inspected via photos only, and permits were pulled after the fact. Shame on the city, but we're waiting for the photos and report to see if it supports that the work wasn't completed. Ask for copies of the, ideally paid, invoices for each work item, and follow up with the companies that did the work to ask about their insurance and the like. You are heavily in get a lawyer territory. Real estate is the type you want. Contact the Bar Association if you don't know where to begin. Not a lawyer, but I absolutely would not close. If you amended the contract for the garage repairs and they signed the amendment, I strongly doubt that they can force you to close without verifying the repairs. The lawsuit threat sounds like a bluff to me. If you can't verify repairs that are in the amendment contract, I would demand my earnest money back and threaten to sue them for the earnest money. All this is assuming that the repairs are well established in the amended contract and signed by the sellers, which it sounds like is the case from what you say here. Not a lawyer. Some thoughts on this. After reading all the responses, yes, you need an attorney, real estate to at least review all of this. You need some level of home inspector familiar with the local building codes to at least walk through. This may be a bit too late on your current timeline, but probably should have been done earlier. One poster touched on receiving paid invoices for all items. You want a statement from the sellers, probably acting as their own general contractor, and lien waivers / releases from each of the subcontractors / vendors that they used. This indicates that the subs and vendors have been actually paid in full. Otherwise, in 3 to 4 months, you will find a lien on the property from someone demanding payment from the long-gone seller. The subs and vendors do not care who owns the property, but the property received their services, labor, material, so the law allows them to lien the property, therefore sticking you with the bill. Geez, if you guys have been through that, that sounds disgusting. I can't imagine having that done. They just don't pay it, and you're like, oh, but we paid those people to do this job. Now we got to pay you? And here is 2 articles if they interest anyone that needs this kind of advice. You indicated that the seller is an LLC who is flipping the property. 10 minutes after closing and the disbursement of funds, upon clearing of the check, the LLC will be an empty, worthless shell. All funds and assets will have been quickly moved elsewhere. If something goes wrong, like a subcontractor or vendor putting a lien on your property, your only recourse will be to sue the worthless shell of an LLC. They may never show up in court since they have nothing to lose. You may get a judgment. However, to execute and collect on the judgment is your problem. You and your attorney will need to return to court, which is time and money, to bust the LLC and be able to apply the judgment to the owners, who have the funds and assets from the sale. To make you whole, that is. This is why you want an attorney to draft the overall release / waiver, to make the collection of any potential judgment a bit easier and less costly. This is where DIY work does not work too well. Thanks for your reply here. This is interesting. And to clarify, we already did one inspection with a very thorough inspector who knows local laws, and even went back to the city to see if the flip work was done with permits. That's why we requested repairs to be made with permits pulled correctly. Any way to look up LLCs and confirm their shells? Right now, the LLC is the property owner. After the closing and disbursement of funds, the LLC will have all of their assets, the cash, distributed and become a worthless shell. This is why the property was purchased within an LLC as a protection mechanism for the actual owners. LLC, Limited Liability Company. So it's virtually guaranteed that this will occur. An hour's consultation with an attorney now may pay dividends, reduced costs in the future. It's a form of insurance. Hopefully the seller has paid off in full all suppliers, labor and material, subcontractors and vendors, and everything will be fine. But you will want a statement to that effect. Note, I would want the seller's LLC to take personal responsibility, but their lawyer will never permit this, and good luck getting such a statement. Talk to your attorney on this point. Hopefully, a year from now, you will be happy without any further problems. However, on the other hand, just in case something does jump the tracks, you will be a bit better prepared. The house I'm living in now, my wife and I purchased 25 years ago. 2 lawyers, husband and wife, were the sellers. At the 3-day walkthrough, there was no power. I had called up APS a few days prior to arrange for the transfer of the utilities on the close date, and the lady on the phone thanked me profusely. At the time, I wondered why. Turns out that they had a $5,000 unpaid power bill, and 30 minutes after I called, they pulled the meter on the house. You can imagine an APS truck speeding across town. The seller had to bring APS cash or a cashier's check. With no power, we could not check out the appliances and refused to close. They were hoping to stick me with their power bill or just walk away with not paying when they skipped town back to Chicago, the day of the closing. They also left me a little present in the garage. The husband had changed his oil before taking off. I heard later that in Kansas, he had burned up his engine. Seems his oil pan plug had dropped out along the way. Oh my god. Just curious why you declined to meet with the seller multiple times. You could have easily voiced concerns at the meetings. Fair enough. First request was after inspection. 1. We were advised not to meet with the builder, both by friends and co-workers, and agent didn't think it was necessary. 2. Our ask was pretty black and white, and the meeting was to discuss completing the work for us after closing. We wanted it done up front. Figured if they didn't want to do the work, they would decline, but then they agreed to do it, so we were happy. The second time they asked, it was last week after we asked why they hadn't started work or pulled permits. We didn't meet because of self-quarantine and COVID. Not sure if we should have met or not. It didn't feel right or necessary, but I'm a first-time buyer, so maybe meeting and discussing the work directly with the seller is normal. Update. Being threatened for $15,000 lawsuit after releasing house contract. Thanks for everyone's advice. We both had a second inspection outlining what work was completed and what was not, plus new issues with the house that were created because of their work, and hired a lawyer who agreed that we did put in full effort to buy and the seller hasn't met the contingencies in the contract. Also, we asked for repairs to meet code, not customizations. He asked if we wanted the house or not. We don't, and then if we wanted to wait it out or sue. I imagine this sentence is, since suing costs time and money, we opted to wait, but send a letter to the seller and agent from our lawyer, asking for the release to be signed by the seller because of all the contingencies not being met, and they are clearly marketing the house as available. If you want to sell it still, release us. The seller had not contacted any of us for a month or returning our lawyer's calls, and is showing/selling the property as available. According to the third-party phone calls to agent and title company, the house is under contract and about to be sold to, supposedly, a different party than us. Our agent has reported them to a state agency because it appears they're trying to close on the property, but we haven't been released. They have opted to remain in our apartment for another year until this is fully settled. Release signed, escrow returned, or court. I'm not sure if we will buy a home in the future. This has spooked us. And if we do, it probably won't be the same type, neighborhood, city, etc. We've learned some things through this. Thanks again for your help. Hope this still gets resolved without court. In Ohio. Rightio guys, I hope you enjoyed that one. I'm not gonna lie, I learned a lot. I didn't realize the scope that people can abuse limited liability companies like that, and just how much of a shake-up that reselling houses can be, but that is very interesting, and I don't know what the hell is going on in this update, but glad that it ended in somewhat a good way, I guess. I'm really confused, like, they sound like they're still tied to that property. Don't know. G'day there guys, Outro Markee here. Hope you enjoyed the episode as much as I enjoyed making it today. If you did, be sure to like, comment, and subscribe. Tell me what you thought about it down below. Also, if you like memes, be sure to head on over to my second channel, Markee 2. It should be one of the sexy Australian faces on screen, the one without the flag. It's my latest and greatest creation, and I hope you like it. Also, I'd like to give a huge shout out to my channel members and Patreon subscribers. You guys do so much good for me, and the support goes without saying, but I'm gonna say it anyway. I love you guys, and I appreciate all the help and support you provide me on this channel. Also, if you want to join the family, links are down in the description below, or click that join button next to the subscribe button. Anyway guys, I hope you enjoyed that one today. I'll see you in the next one. Bye!